Thank you, Chair Barber. It's good to see you. And of course, Chair Day, who I think is online, is that correct?
No, his staff are here. But,
Oh, okay, then thank you, Chair Barber, and thank you, of course, to the rest of the committee. It's great to see my representative, Brandy Fluker-Oakley. It's great to see you. She represents my district, so I have to give her a shout out. She's working hard on our behalf. I really appreciate you taking me out of turn to be able to testify today on some important pieces of legislation and, of course, proposals relative to the juvenile and criminal legal reform issues of the day. And I also want to thank the people who are sitting behind me because I recognize that people got here early to testify, so thank you to them for allowing me to go out of turn. Today, I'm here to convey my strong support, in particular for House Bill 1710 and Senate 942, an act to promote public safety and better outcomes for young adults, more commonly known as legislation to raise the age. I want to thank Representatives Jim O'Day and Manny Cruz and Senator Brennan Crichton for their leadership in filing this bill, which over the course of 5 years would raise the age of juvenile court jurisdiction to include 18, 19, and 20-year-olds. This phased-in timeline will allow state agencies to adequately plan and prepare for transition. Raise the age would promote positive outcomes for our youth, reduce recidivism, and improve public safety across the Commonwealth. My office and I personally are deeply acquainted with the compounded harm and risk to public safety that results from incarcerating youth in adult correctional facilities. As a former lawyer for the Ed Law Project who represented clients ensnared in the school to prison, and actually I would say the cradle to prison pipeline, I witnessed firsthand the harm that results from imposing overly punitive consequences on our young people. And as some of you may know, my own personal story is connected to the incarceration system. I still have loved ones who are incarcerated. Much of those folks, including my twin brother, got involved in that system as a juvenile. And as some of you know, my twin brother Andre died 11 years ago while in the custody of the Department of Correction. Clearly a system that did not work then for him and many others. Young people are particularly susceptible to the influence of their environments. Incarcerating youth in the adult system can have irreparable effects on their physical and mental health and disrupt their education, path to graduation, or career altogether. And incarcerating young people in adult correctional facilities does not make our communities safer. In fact, young people have the highest, not the middle, not somewhere at the bottom, the highest recidivism rate of any demographic in the adult system, with 76% rearranged in the next 3 years, with a disproportionate and devastating effect on the impacts, I should say, on youth of color and their communities. By contrast, new admissions to DYS dropped from 344 to 90 between 2013 and fiscal year 2021. And as we all know, that's when Massachusetts decided to raise the age of juvenile jurisdiction to include 17-year-olds. During that same time, there were similar decreases in juvenile arrest and summons since the legislature last raised the age. The latest science is clear that teen brains and adult brains operate differently. The adult brain, especially the prefrontal cortex in particular, isn't fully developed until around age 25. And why this is important, because it has implications for a young person's capacity for impulse control and self-regulation. And at the same time, the young brain is more elastic and receptive to rehabilitation. And I want to just stress that the bill before you, of course, doesn't push it to 25. It reasonably suggests that we move to 18, 19-year-old, and 20-year-olds and do it over a period of 5 years, which is, of course, reasonable. Consistent with this research and with a positive youth development approach, DYS provides rehabilitation services, therapeutic treatment, education, job training, all of which support young people in their successful reintegration into their communities. This system provides the right balance of accountability and rehabilitation all at the same time. We cannot miss this opportunity and moment to invest in our young people and, frankly, to do something that has been advocated by advocates, residents, those who are formerly incarcerated, and so many others for so many years. We know it works, and it's about time, I think, that we all work in partnership to build a system that will support these 18-year-old, 19-year-old, and 20-year-olds in a reasonable way, and with the supports we know will generate a system that produces accountability and rehabilitation. Lastly, and of course, we stand ready to support the trial court, DYS, all agencies, and all of you in doing this work. Lastly, I want to just lift up and take a moment to lift up another piece of legislation. This is Senate Bill 1049, an act relative to diversion for primary caretakers filed by Senator Liz Miranda. I equally and strongly support this bill, which creates an opportunity for pretrial diversion for primary caretakers of children, primary caretakers of aging or sick immediate family members, and pregnant persons. Incarceration of primary caretakers inflicts both financial and emotional harm on the defendant's children, making them far more likely to be suspended from school, removed from their home, and eventually incarcerated themselves. There is substantial data here that speaks to that, and we can share that because I know we've run out of time, but we will share that with this committee because it is useful, and I'm sure the senator has as well. But these bills go hand in hand and are both, I think, a step in the right direction when it comes to juvenile justice reform and criminal legal reform. Thank you again for taking that a turn. Senator Eldridge, it's great to see you. Thank you for your work. And I just have to acknowledge these two incredible team members. Liza Hirsch, who runs our Children's Justice Unit, is at the front lines of doing this work every single day. And David is an AAG and an assistant attorney in our Civil Rights Division, who also prepared an incredible memo on the second bill that we will share with you as well that is helpful. They work really hard, and I want to acknowledge their hard work. So thank you all. Happy to answer any questions.
Thank you, Attorney General Campbell. Thank you to your team.